What's up everyone, it's the Law School Lumberjack here for another installment of Property Law 101, Fee is Not Simple. Today we're going to be going through the case of Thomas and Murphy. Now I know this case has caused people quite a bit of trouble, so hopefully I can shed some light on the case, its application, and assist you in understanding the basics of the case. Without further ado, let's move on to the facts. So the facts of this case are as such. So I'll set out the current state of affairs with respect to the case, and then I'll go through some of the backstory that helps make this case make sense. So basically this case involves Thomas, this man, suing Murphy, who's his lawyer, with respect to some land that was transferred to him by a transferor named Bob. Now just remember, for ease of reference, a transferor is the person who transfers land to someone. A transferee is someone who obtains the land. So in this circumstance, Bob is the transferor and Thomas is the transferee. So now let's take a step back and figure out how Bob actually obtained this land and what's going on. So Bob's dad, who is now deceased, gave his land to Bob through his will. So essentially what happens is the dad stated to Bob and his successors. However, based on the strict doctrine of construction, and the formalistic law, which is basically the Old English law, stating to Bob and his successors was not enough to give a fee simple interest. Remember, in the Old English law, you had to say to Bob and his heirs for it to be fee simple, rather than to Bob and his successors. Instead, all it gave was arguably a life estate. So essentially, Bob, being a layman, based on just a plain reading of the will, thinks that he in fact has the land in fee simple. However, he actually arguably has a life estate. So basically what happens is Bob thinks that he has the land in fee simple, so he wants to sell it to Thomas to get some money. Thomas then asks Murphy whether or not Bob has true title to the land or fee simple interest in the land. Murphy says based on the basic reading or a plain reading of the will, yes he does, so Thomas buys the land. As time goes on, Thomas begins to wonder whether or not Bob actually had a fee simple interest to give him. Thomas later finds out that Bob did not have a fee simple interest and just had a life estate. So Thomas sues Murphy and they go to court over this. The court says yes, based on the old formalistic law of England, Bob only had a life estate interest in the lands. However, the court takes one step further and says, in the circumstances though, it was clear that Bob's father intended for this land to be transferred to Bob in fee simple. It was just a mistake in wording and the intentions were very clear. And it's a very formalistic way of viewing it if we were to treat it as a life estate, just because Bob's father used the word successors rather than heirs. The court says, in the circumstances that doesn't make any sense. It's clear Bob's father wanted Bob to take the land and his heirs to take the land after Bob is deceased. Bob really had fee simple. So the case is dismissed because Thomas, even though on the plain reading didn't get the fee simple interest from Bob, in the end the court rectified the will. Bob had the fee simple interest, was able to transfer it to Thomas, and as a result, Thomas got the fee simple interest. I hope you guys liked this video. If it was helpful, please feel free to subscribe and like this video. Take care and see you next time.